Happy morning or happy evening, all of you all.
Happy evening,
Happy
sir.
evening,
sir.
evening, sir.
So welcome to R2C, refresh, relax to cherish. What is it? Refresh to cherish. And we will be, what we will be doing, 1 minute. Let me put on my video also. My video is on now, Bhavna. Can you see me?
Yes, sir.
So what we'll be doing is in these 2 hours is trying to discuss how this entire business law paper has to be handled and what are the types of questions which appear and how do you handle those questions. So for this entire purpose, what we are going to do is first, you know the format of the paper and I'll repeat it again just to start off. Remember your entire mercantile law plus business correspondence and reporting is a 100-mark paper, out of which your business law is how many marks? 60 marks, and your business correspondence and reporting is 40 marks, correct? Now, in this business law paper for 60 marks, you have to answer 5 questions of 12 marks each. So 12 into 5 will make it 60 out of 6 questions. What out of 6 questions? But out of these 6 questions, the first question is compulsory. What the first question is? Compulsory. And out of the remaining 5 questions, that is 2, 3, 4, 5, 6, you have to attempt any 4 questions. What you have to attempt any
4 questions.
Generally, what happens is that the question 1 is generally from the Indian Contract Act, Sale of Goods Act, or Companies Act. So generally, the 3 questions it comes. Sometimes, very rarely, it comes from the Partnership Act, but most of the time, those 3 questions are compulsory at 12 marks from there, right? Out of the remaining 5 questions, I think so. In question 2, you will have 1 5-mark questions related to limited liability partnership. What related to limited liability?
Partnership.
That's the only question which comes from limited liability partnership. Only 1 5-mark comes. All the remaining questions will have either 2 marks, 3 marks, 4 marks. Maximum it goes to 5 marks, which will be either from the Indian Contract Act or from the Sale of Goods Act or from the Companies Act or from the Partnership Act. All will be mixed up. What all will be? It's not that question 2 is only Indian Contract Act, question 3 is only Partnership Act, question 4 is, they will all be mixed up. So the first question may be from the Contract Act, the second question may be from the Partnership Act, the third question may be from the Companies Act. Okay, like that you will have different questions. Now the first thing is, those 4 questions which you attempt, you have to be very smart in attempting those questions. So what you should do is very quickly, when you get the paper, look through those questions. Second, third, fourth, fifth, sixth. Now remember, all these questions from 2 to 6 will have at least 1 case study. What will have at least 1
Case study.
Case study in each question. What in each question? But sometimes the case study will be of 3 marks or 2 marks. Sometimes it will be for 4 marks or 5 marks. Now, if you are not comfortable doing case studies, then attempt the question which has the least number of marks with case study. So see that one which has the maximum marks of a case study, leave that off and do the remaining questions, because as I told you, there will be a mixture. So out of those 48 marks which you have to choose, the first 12 marks is compulsory, you can't do anything about it. Also 48 marks which you choose, at least around 20 marks will be case studies, or 15 to 20 marks will be case studies, and the remaining 28 to 30 marks will be questions, right or no? So just go through the question and see ones which you know, because choosing the right question is also very important. Out of those 5 questions, you should be able to choose the right question, right? Because it makes a difference, right? I know it's only one choice, but suppose you chose a wrong question, you chose for 12 marks, and out of that you get only 3 or 4 marks, and the other question, if you'd have chosen, you would have got 9 or 10 marks. It makes a big difference of 7 marks, which may be the difference between you passing or not passing this paper, right? So be smart while choosing the questions, right? Now, how do the questions come and what are the topics covered in the questions? We will discuss in these 2 hours, because we'll be doing at least 2 or 3 revision test papers and we'll see how they answer the questions, correct or no? But before we start the question papers, let's recap what I have done. Did you all have an R2C class with Mehul already?
Yes, sir.
Yes, sir.
What did he do with you all?
Indian
IPA and
Partnership
LLP.
Huh?
IPA and LLP, sir.
Partnership Act and limited
So what did he do? Did he do revision test papers or he did the whole?
He
Sir,
summarized
we
the
revised
complete
the whole
chapter, sir.
syllabus.
Okay, I won't be doing that. Correct. I'll be doing the revision test papers so that you all will have an idea. So now just understand in this entire these 5 questions which you have for 60 marks, which you have to answer. The first question is 12 marks and the 48 marks. As I told you, there are 2 types of questions which come. The first type of questions are direct questions. So they'll ask you, explain the concept of separate legal entity. So this is a direct question. So you will explain a company is a separate legal entity, it's different from its shareholders. Then you can give that case Solomon versus Solomon, correct or no? Okay, and you will mention what is a separate legal entity for those type of questions which are direct. Remember, I told you you have to have an opening, a body, and a conclusion. What you have to have an opening, a body, and a. So explain first what is a separate legal entity, then explain the concept of separate legal entity, and then last one, give the case study and wind up. Therefore, the company has secret. So it should always have an OBC, an opening, body, and
Conclusion.
or for example, if they ask you what are the essentials of a valid contract which are not mentioned under section 10 of the Indian Contract Act, not mentioned under section 10 of the Indian Contract Act. So what are the elements, what are the essentials of a valid contract not mentioned under section 10? You will have 2 parties, yes or no? It should be certainty of meaning. They should complete other formalities, correct or no? Intention to create legal
Obligation.
legalization. You will mention. So you will write a contract is as per section 2H, give the opening, and there are certain essentials. There are several essentials given under section 10 and so on. We are going to discuss which are not under. So you'll write first one, 2 parties. Second one, you'll write certainty of meaning. Third, you'll write intention to create legal relation. Fourth, fifth, and then you'll write the conclusion. So whenever there's a direct question, always have an opening where you will state the meaning or definition of what they are asking. Then you'll go to the body where you'll mention all the points, and then you'll give a conclusion. What then you'll give a
Conclusion.
conclusion, right? That is how you go through a direct question. Second is, how do you go through a case study? So they will give you a question. Mr. Sham took his wife to a departmental store and she saw a beautiful sari on display at one of the departmental stores which was run by Shantala Silks. Correct? She liked the sari and she went to the shopkeeper and she said, I want the blue sari which is displayed in the shop window. And she brings it to him and she says, I'm willing to pay 2,000, which is mentioned in the price tag of the sari. But he says, sorry, madam, I have already sold this sari to another customer, so I cannot sell it to you. The lady argues that if he had sold it, why did he keep it on display? And she demands him to sell the sari only to her because she had brought it to him for the purchase. Analyze the case and discuss whether the shopkeeper is right or Mr. Sham's wife is right. What Mr. Sham's wife is right. Now, how will you discuss this case? Now, whenever you get a case study like this, first you will write the facts of the case. What you'll write the facts of the case. You will write the entire summary of the case. Mr. Sham's wife was taken there and display a window. Second, you'll write provisions of the act. What you'll write provisions of the act. You'll write as per the Indian Contract Act, there is a concept under section 9 which is called as offer and invitation to offer. What it is called? Offer and invitation to offer. Any display of items does not amount to offer, but it amounts to invitation to offer. You'll write 2 or 3 lines about that. Correct or no? As per the case of as per the case, then you'll give the analysis. Then you'll give the analysis since it's an offer. When Mrs. Sham takes it to the shopkeeper, she's making an offer and it is up to him to offer, as was discussed in the case of Harris versus Nickerson, or this case is similar to Booth's case, Chemists versus Pharmaceutical Society of Great Britain. And then you'll and then conclusion, Mrs. Sham has no right over the sari because the shopkeeper has to decide whether he will sell it to her, because display of goods is not an offer, it is an invitation to
Offer.
So you will divide the entire part into FPAC, facts of the case, provisions of the law, analysis, conclusion. Got it or no? Now, in your RTPs, which we are going to discuss now in the next 5-10 minutes, they have not divided the entire answer into 4 points. But sometimes what they do when they give you a case study, they give you 2-3 questions under the case study. You don't have to ignore those questions. Suppose they've given the first question, give the answer to the first question. The second question, here I told you analyze the case, right? So you could do facts, provisions, analysis case. But in the question paper, if they give you 2-3 questions, as the question is asked about this, answer that. So if they're giving you one question, follow facts, provisions, analysis question. Even if they give you 2 or 3 questions, follow that, but you write over there as asked in question 1A of the sub question A, this is what it is. In the analysis part, as discussed in question part B, this is the answer. Got it or no? So that they know that you're answering all the questions. What they know that they are answering all the. Understood or no?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
You all got what I'm trying to tell you? Right?
Yes, sir.
Yes.
So this is nothing but your, what is it called as your, it is the way in which you answer the 2 types of questions. Now, it will be impossible for me to do in 2 hours Indian Contract Act, Sale of Goods Act and Companies Act, which are very, very big. So what we have decided to do is, we have decided to go through the revision test papers. What we'll go through the revision test.
Papers.
When is your exam? When is it starting? December what?
31st, sir.
December 31st.
Yes, sir.
Okay. And so we will go through these the RTPs and just see the answers, how they're given. In case, if we feel that the answer is, if you want me to explain any part of the answer, we'll explain it. Otherwise, we will see, usually what they do for the answer, they copy paste it from the study material. So actually you'll be going through the study material. In case we see that we are not able to complete 1 or 2 papers, but I want you to go through the revision test papers, because most of the questions generally appear in the exam based on the revision test papers. Did Mayul sir do RTPs with you? Not yet, right?
No, sir.
Okay, so we will do revision test papers. Got it or no?
Yes, sir.
Yes, sir.
So now Bhavna
Yes,
has
sir.
the revision test paper.
Yes,
Which
sir.
one are you doing? From which year onwards you are doing?
Sir, Ananyaka sent me from May 22nd to December 23.
May 22, December 22.
June 23 and November 22.
Okay, so which is the latest one?
December 23.
Okay, so we'll see this revision test paper. Sometimes they give you even sometimes same question also from the December. We'll see that. I have not seen this one. I didn't get it recently. So we'll go through these 4 RTPs. What we'll go through these 4 revision test papers. Your revision test papers is like a mock paper, out of which generally they give at least 8 or 10 marks, 10 or 12 marks. So we'll see. And you'll get an idea on how the paper is written and how it is solved. Got it or no? Yes, you can go ahead, Bhavna.
Yes.
Okay, are you sharing the screen?
Yes, sir. Done.
Okay, you'll only be reading?
I'll do it, sir.
Okay.
Paper 2, Business Laws and Business Correspondence and Reporting. Section A, Business Laws. Amendments for Paper 2A, Business Laws, Foundation November 23 examinations. First one, Chapter 4, the LLP Act 2008. The Limited Liability Act 2008 has been amended through the Limited Liability Partnership Amendment Act 2021, dated 13th August 2021. Following are the amendments with effect.
Okay,
from-
this Mayul sir would have told you all, right? So I don't have to do it, right? He's done this with you, right? LLP. I didn't do the LLP Act with you, right?
Yes.
Did you all? Okay. You send it in the group, they'll read these amendments, right?
Yes, sir. Already sent.
Okay. This amendment 1, 2, 3, 4. Then what is the next after the amendments?
After the
How many
amendment,
amendments are there?
so many of this one.
When does the paper start?
Like the time of the writing, sir.
No, this is a revision test paper or this is an amendment. What are you reading? RTP, right?
Yes, sir. It was given
sorry.
RTP only.
Then what is this? Inside the RTP, there are amendments, right? You're reading.
Yes, sir. At the beginning, they have given amendments, sir.
That's what she's telling.
After
There's
few
only a-
pages, there's question.
Sir, it's from
Ah.
page 16, sir.
From
Sir,
page.
page
16.
we started the question.
Yes, sir. Questions and answers. Questions. First one. Sheetal was a classical dancer. She entered into an agreement with Sharad Vidya Mandir for 50 dance performances. As per the contract, she was supposed to perform every weekend and she will be paid rupees 8,000 per performance. However, after a month, she was absent without informing due to her personal reasons. Answer the following questions as per the Indian Contract Act 1872.
See, now they're going to answer the following questions as per the Indian Contract Act 1872. So now see, this is a question where they're giving you a case study, but they're giving you questions related to the case study. How many questions are they given? Read the first one.
First sub question, whether the management of Sharad Vidya Mandir has right to terminate the contract.
Yes, this is question number 1. So keep this in mind. Okay. Second point.
Second sub question, if the management of Sharad Vidya Mandir informed Sheetal about its continuance, can the management still resign the contract after a month on this ground subsequently?
Okay. Now this is you will write facts of the case. Mrs. Sheetal entered into a contract with Sharad Vidya Mandir for 50 dance performances of 8,000 each, and she willfully absences herself after 1 month. Correct or no? That's the facts of the case, right? Then provisions of the act. What are the provisions of the act? This is a breach of contract. What this is as per the Indian Contract Act. This is as per the breach of contract. And since there is a breach of contract, there are 2 remedies which are available for the Sharda Vidya Mandir. Then you write as per, now the way they've answered, I'm telling you differently, but the way I would have answered is this, okay? And this is an easy way of answering. As asked in question subsection 1, can Sharad Vidya Mandir terminate the contract? Yes, it can terminate the contract if Ms. Sheetal has willfully absented herself, because if there is a breach of contract for a continuing contract, one of the options available for breach of contract is rescinding the contract. What? Rescinding the contract. However, as per section part 2 of the question which has been asked, if they continue with Mrs. Sheetal singing, then they are giving silent consent for continuing the contract, and therefore they will lose the right to rescind the contract after 1 month. So if they continue with Mrs. Sheetal as a dancer, they cannot cancel the contract or rescind the contract after 1 month of entering into the contract. Then you'll write analysis, breach of contract can attract that, and conclusion, as per section 1, they can terminate the contract. As per part 2, they cannot terminate the contract. Understood or no? You all understood?
Yes, sir.
Yes.
Now just see the way they've written the answer. Read the answer which is there.
Sir, still the last sub question is there. Can the Sharad Vidya Mandir claim damages that it has suffered because of this breach in any of the above cases?
Yes, definitely. I didn't know. There is a fourth part also. How many sub questions are there?
Sir, only 3.
Okay. So as per the part 3, they can claim damages if there is a loss incurred due to the absence of Mrs. Sheetal. So that also I would have mentioned in the analysis of the contract itself, right? In both the cases, whether they decide to continue with the contract or they decide to rescind the contract, in both the cases, they can claim for
damages.
That's also you will mention in the analysis. Okay. Now read the answer which they're given. Okay.
Section 39 of the Indian Contract Act 1872 provides that when a party to a contract has refused to perform or disabled himself from...
This is a breach of contract. This is section 39. I didn't mention the section. Don't mention the section if you don't know. Okay. Or don't just bluff a section. If you know, but now remember it. Section 39 is what? Breach of
Contract.
contract.
Or disabled himself from performing his promise in its eternity, the promisee may put an end to the contract unless he had signified by words or conduct his acquiescence in its continuance. Further, in terms of section 40, the promisee shall require to perform personally if there is such an apparent intention of the parties. Also, as per section 75 of the Act, a person who rightfully rescinds a contract is entitled to compensation for any damage which he has sustained through non-fulfillment of the contract. Therefore, in the instant case, first sub-question, since Sheetal could not perform as per the terms of contract, Sharad Vidya Mandir can terminate the contract.
This is part 1. Correct or no? Remember, answer part 1, part 2, part 3. Correct or no?
Yes.
They can terminate the contract as per section 39. Okay. Part 2.
Second sub-question. In the second situation, the management of Sharad Vidya Mandir informed Sheetal about the continuance of the contract. Hence, the management cannot rescind the contract after a month on this ground subsequently.
This is section 40 or this is section 40. And last one.
Last one, as per section 75, Sharad Vidya Mandir can claim damages that has suffered because of the breach in part 1.
Okay, so they can claim breach under part 1. And as for part 2 also. Even if they continue the contract, they can ask her for breach of for damages, or they can ask for damages. So remember section 9, 30, 40. So you all understood how to answer this question. This is the way the question will be asked in the exam. This is a compulsory question, right? Continue. Read the next one.
Second one, Paridhi, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Mittal, owner of MP Laptops, for purchase of laptop on credit amounting 60,000 on 1st August 2022. She promised to pay back the outstanding amount with interest at 16% per annum by 31st July 2023. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Paridhi was asked to pay the outstanding money with interest, she refused to pay the amount and told the owner that she is minor and now he can't recover a single penny from her. She will be a major on 1st January 2025 and only after that agreement can be ratified. Explain by which of the following ways Mr. Mittal will succeed in recovering the outstanding money with reference to the Indian Contract Act 1872.
So now look at the
First sub-question. By filing a case against Paridhi, a minor of recovery outstanding amount with interest. By filing a case against Mr. Ram, father of Paridhi, for recovery of outstanding amount. By filing a case against Paridhi, a minor, for recovery of outstanding amount after she attains majority.
You tell me. All of y'all, we have done minor, no? Can Mr. What's that fellow's name? The laptop dealer recover the money? Don't see the answer. All of y'all tell me. Huh? Mr. Mittal. Can Mr. Mittal recover it? In which of these 3 cases can he recover the money? That's why I'm doing cases with you. See, now you all understood what comes in the exam, right or no? Can he recover?
No, sir.
No, sir.
In which case can he recover? Can he recover in case 1, 2, or 3? Can he recover in case 1? When she's still a minor?
No, sir.
No, sir.
Can she recover the money from her father?
No, sir.
No, sir.
No, sir.
Money when she reaches majority?
No, sir.
Then how can he recover the money? Suppose he wants to recover the money. Is there any way in which he can recover the money?
If there is any property in the name of the minor.
And he proves that the laptop was a necessity of life. What it was proves that it was a necessity of life, which he needed for her education. Only then he can recover the money. But in these 3 circumstances, he cannot recover the money because my contract with a minor is null and void. And First point, contract with a minor is null and void. Second point, contract with a minor cannot be recovered from the guardian of the minor, because the guardian will not be held responsible for any contract entered into by the minor. Third point, a minor cannot ratify the agreement which she has entered into when she was a minor. Remember, ratify, she cannot make good an agreement, because at the initial stage itself it was null and void. The only way in which Mr. Mittal can recover the money is if he can prove. I don't know, they didn't ask that question, but I am telling you. Suppose they would have asked another question. In what way could he have recovered the money? He can recover the money if he proves in the court of law that the laptop was given to Miss Paradhi as a necessity of life, which she required at that stage of life for her education. In that case, Paradhi will not be held liable, but her property which she owns will be held liable to recover the amount.
Money.
Correct? Otherwise, in all these three cases, he cannot recover the money. She'll read out the answer and you see how they've written the answer. Go ahead. Bhavna.
Yes, sir, just a minute. A contract made with or by a minor is void ab initio, pursuant to Section 11 of the Indian Contract Act 1872.
Remember Section 11, I've already told you. Remember the jail, when you're in a minor, all persons who cannot enter into a contract are given under Section 11.
A minor is not competent to contract, and any agreement with or by a minor is void from the very beginning. First sub-question. By following the above provision, Mr. Mittal will not succeed in recovering the outstanding amount by filing a case against Paridhi, a minor. Second one, minor cannot bind parent or guardian. In the absence of authority, express or implied, a minor is not capable of binding his parents or guardian, even for necessaries.
No,
The
you cannot.
The parents will be held liable only when the child is acting as an agent for parents.
This is also important. Okay.
In the instant case, Mr. Mittal will not succeed in recovering the outstanding amount by filing a case against Mr. Ram, father of Paridhi. No ratification after attaining majority. A minor cannot ratify the agreement on attaining majority, as the original agreement is void ab initio, and void agreement can never be ratified.
Void agreement can never be
Ratified.
Correct or no? Yes or no?
Yes.
And you can give the case. What you can also do is, when you are mentioning a case cannot be recovered from minor, mention as mentioned in the case of Moiri Bibi versus Dharmodas Ghosh. You don't have to explain the case, but write the name of the case. But Moiri Bibi versus Dharmodas Ghosh. Correct or no? Yes or no?
Yes, sir.
And a minor cannot ratify the agreement after reaching the age of
Majority.
There also you can mention the case. I've done 2 cases with you, right? Correct or no? They Leslie versus Shale and all that. Correct or no? So just mention the name of the case. You don't have to explain the case. But if you mention the case, they'll give you some marks. So they'll give you some marks. Understood or no?
Yes, sir.
Yeah.
Yes.
Hence, in this case also, Mr. Mittal will not succeed in recovering the outstanding amount by filing a case against Paridhi after she attains majority.
Okay. Let's go to the next question.
Rohan found a wallet in restaurant. He inquired all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep the wallet till the true owner is found. After a week, Rohan went back to the restaurant to inquire about the wallet. The manager refused to return it to Rohan, saying that it did not belong to him. In the light of the Indian Contract Act 1872, can Rohan recover the wallet from the manager?
This is a quasi-contract. Remember, finder of lost goods. Section 67, 68, 69, I think, right? Finder of lost goods, or 70. Just read it. And remember, in this case, this is similar to a case which I done with you. Remember, it was there in the study material. A person lost her jewelry in a jewelry shop and he gave it to the owner, and then he asked the jewelry owner back for the money. He did not give it. But the court held that whoever is the original finder of the goods will have the right to keep the goods till he finds the person who has lost the goods. So here Rohan has every right to keep the wallet till such time as the original owner is found, and the restaurant owner has no right to recover the gun. This is which case? I forgot the name of the case. Which was the case? Anybody can see your study material. Go to Finder. Go to quasi contracts. All of y'all have your study material.
Yes,
Who will
sir.
do- go to your study material. Go to quasi contracts and see the name of the case. I've done this case, but I also forgot the name of the case. I'm also an idiot. Correct?
Hollins versus Howlers.
Yeah, correct. What's the case name? Hollins versus who gave
Howler.
name? Spell it out.
HOLLINS versus HOWLER.
OWLER.
Yeah, yes, sir. HOWLER.
So both are starting with H. HOLLINS versus Howler.
Yes, sir.
Okay, so
Yes,
this
sir.
is the case. This is exactly. So you will mention over there. This case is similar to the case of Hollins versus Howler, correct or no? And then give the case of that. So remember that if you mention the name of the case, the chance of you getting more marks becomes much, much higher. Who gave that answer? What's your name?
Chauhan.
Very good, Saurabh. Excellent. Keep it up. So that is the answer. It's Hollins versus Howler. What is Hollins versus Howler? So the finder of lost goods has the right to the goods against the whole world. What has the rights of the goods against the whole
World.
world? Okay, read the answer, Bhavna.
Responsibility of finder of goods, section 71 of Indian
Section
Contract.
71. Okay, I got confused. So remember, right from section 67, 68, 70, 71, 72. You have all the quasi contracts. So this is under quasi contract. Finder of responsibility of finder of lost goods. Correct or no?
A person who finds goods belonging to another and takes them into his custody is subject to same responsibility as if he were a bailey. Thus, a finder of lost goods has to take proper care of the property as man of ordinary prudence would take, no right to appropriate the goods, and to restore the goods if the owner is found.
Found. Correct or no? So these are the responsibilities of a finder of lost goods. Correct or no? Take care of the goods as an ordinary man of prudence was. Remember, I told you, there was a lady who left her jacket in a shop and the person didn't lock the drawer. So he was held liable because he did not take care of the goods. Correct or no? Second, he cannot appropriate the goods. He cannot use the goods for his own purpose. And third one, he has to return the goods when he finds the original owner.
Owner.
What is that? Owner. Understood or no?
Yes, sir.
Hmm.
In the light of the above provisions, the manager must return the wallet to Rohan, since Rohan is entitled to retain the wallet found against everybody except the true owner.
True owner. Understood? Next.
Mr. Sohan, a wealthy individual, provided a loan of 80,000 to Mr. Mukesh on 26 February 2021. The borrower, Mr. Mukesh, asked for a further loan of 1,50,000. Mr. Sohan agreed but provided the loan in parts of different dates. He provided provided the loan in parts on different dates.
Okay.
He provided 1 lakh on 28th February 2021 and remaining 50,000 on 3rd March 2021. On 10th March 2021, Mr. Mukesh, while paying off part rupees 75,000 to Sohan, insisted that the lender should adjust rupees 50,000 towards the loan taken on 3rd March 2021 and balance as against the loan on 26th February 2021. Mr. Sohan objected to this agreement and asked the borrower to adjust in the order of date of borrowal of funds. Now you decide, first sub-question, whether the contention of Mr. Mukesh correct or otherwise as per the provisions of the Indian Contract Act 1872. Second question, what would be the answer in the case the borrower does not insist on such order of adjustment of repayment? Last one, what would be the mode of adjustment or appropriation of such part payment in case neither Mr. Sohan nor Mr. Mukesh insist any order of adjustment on their part?
So remember, this is rule of appropriation of payments, or this is rule of appropriation of
Payments.
what did I tell you? If a person has given loans on different dates, if a person gives a loan on different dates, then if the part of the loan is repaid by the debtor, what if the part of the loan is repaid by the
Debtor.
then point one, the debtor decides which loan has to be repaid first and which loan has to be repaid second. So answer to question one is Mr. Mukesh is right. He can decide whether he wants to repay the last loan or the first loan or the middle loan, because when there are loans given on different dates, it is the prerogative or it is the right of the debtor to decide which loan has to be repaid. Second, in case Mr. Mukesh does not decide and just repays rupees 75,000, then it is up to the creditor to decide. That is Mr. Sohan to decide which loan he wants to get repaid first. Which loan he wants to get repaid
First.
first. Answer to question 3. If neither of them decide, neither the creditor or the debtor, then we follow the rule in Clayton's case. What we follow the rule in Clayton's case? Clayton's case is Devons versus Nobles. I told you it's not there in the textbook, but write it down. Rule in Clayton's case, Claytons. Clayton's case or Devons versus Noble, Dewaynes versus Nobbels, where the loans will be discharged in a chronological order. That is, the first loan taken will be the first loan discharged, or the first loan taken will be the first loan discharged, right? So whatever loan he's taken first, that will be paid first, then the second loan, then the third loan. Understood or no?
Yes, sir.
Yes, sir.
Yes, sir.
No. What do you know?
Appropriation of payments in case where a debtor owes several debts to the same creditor and makes payment, which is not sufficient to discharge all the debts, the payment shall be appropriated, that is adjusted against the debts as per the provisions of Section 59 to 61 of the Indian Contract Act 1872.
So 59 is debtor decides, 60 is creditor decides, 61 is chronological order. What's chronological order? Okay.
First sub-question, as per the provisions of 59 of the Act, where a debtor owing several distinct debts to one person make a payment to him either with express intimation or under circumstances implying that the payment is to be applied to the discharge of some particular debt, the payment, if accepted, must be applied accordingly.
Accordingly, that means the debtor will decide. What the debtor will
Decide.
Okay.
Therefore, the contention of Mr. Mukesh is correct and he can specify the manner of appropriation of repayment of debt.
Of law. So he can decide which one he has to repay first. Okay.
Second one, as per the provisions of 60 of the Act, where the debtor has omitted to intimate and there are no other circumstances indicating to which debt the payment is to be applied, the creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor, where its recovery is not barred by the law in force for the time being as to the limitation of suits.
No,
Hence-
Section 60.
Hence, in case Mr. Mukesh fails to specify the manner of the appropriation of debt on part repayment, Mr. Sohan, the creditor, can appropriate the payment as per his choice.
Third point,
one,
61.
as per the provisions of 61 of the Act, where neither party makes any appropriation, the payment shall be applied in discharge of the debts in order of time, whether they are or are not barred by the law in force for the time being to the limitation of suits. If the debts are equal standing, the payment shall be applied in discharge of each proportionately.
Okay, that is if they are not equal, but this was not equal. This will be as per chronological order. What this will be as per chronological order. What they mean to say, if two debts are taken on the same date and you make the payment, then the debts will be discharged in the ratio of the loans which are taken. So suppose you have taken a loan of 60,000 and 40,000 on the same date, February 1st, and the person repays back 50,000. And neither the creditor nor the debtor has decided. Then that 50,000 will be repaid in equal proportion. What is the ratio? 6 is to 4. 60 is to 40, 6 is to 4. 30. 30,000 will go to 60,000 and 20,000 will go to 40,000.
40,000.
Hence, in case where neither Mr. Mukesh nor Mr. Sohan specifies the manner of appropriation of debt on part repayment, the appropriation can be made in proportion of debts.
It should be made in chronological order. Wrong. It should not be as per appropriation. This is the wrong answer. It should be made. They are not taking the loan on the same date, right? It will be recharged in chronological
Order.
Understand? They made a mistake here. They made a
Mistake.
Read section 61. So, just go to that topic, no? Appropriation of payments. It comes under discharge of contract, I think, right?
Yes, sir.
Just he'll read out that part, so you'll understand that it's not as per proportion. If they are on the same date, it's the proportion. But otherwise, it is in chronological order. That means the first loan taken is the first loan
Paid.
discharged. Correct or no? Did you find it by any chance?
Yes, sir.
Yes.
Application of payment where neither party appropriates, section 61. Where neither party makes an appropriation, the payment shall be applied in discharge of the debts in order of time.
In order
Whether
of
they-
time.
Yes.
In order of time. That is first, yeah.
Whether they are or are not barred by law in force for the time being as to the limitation of suits. If the debts are of equal standing, the payment shall be applied in discharge of each proportionately.
Okay. But otherwise, it will be in order of time. What it will be in order of
Time.
Order of time means chronological order. First loan taken is the first loan discharged. Got it or no? Yes. Did you understand?
Yes, sir.
Yes.
Okay. Okay. Boom.
Fifth one, state with reasons whether the following agreements are valid or void as per the Indian Contract Act 1872.
Okay. So now they are asking whether the agreements are valid or void. You all will have two R2C classes. Now one and later on also one, or only one?
No, sir, only one.
Okay.
First one, where two courts have jurisdiction to try a suit, an agreement between the parties that the suit should be filed in one of those courts alone and not in the other.
This is okay, valid. Just read the answer.
Just a minute, sir. The agreement is valid. Reason, an agreement is restraint of legal proceeding is the one by which any party thereto is restricted absolutely from enforcing his rights under a contract through a court. That is section 28 of Indian Contract Act 1872. A contract of this nature is void. However, in the given statement, no absolute restriction is marked on parties on filing of suit. As per the agreement, suit may be filed in one of the courts having jurisdiction.
Okay, now let's understand this. Okay, what are they trying to say? Now let's say Bhavna sold goods to Saharda, correct? And she sold it on the border of Maharashtra and Karnataka, correct? And at that place, you have the Mumbai High Court also, which has jurisdiction, and you have also the Bangalore High Court, which also has jurisdiction. Now, Bhavna is telling that you cannot file the case anywhere. You are telling the goods that you have to file it in Bangalore only. So Arda is telling, I'll file the case against you in Mumbai High Court. Now, is this agreement valid? Can you say that he cannot file it in Mumbai, he has to file it only in Bangalore? No. See, there is restraint of legal proceeding. If you say that if we enter into an agreement, you cannot file the case in any court, then it is void. What then it is? Void. But in the agreement, if it is mentioned that there are two courts which have jurisdiction and any one of the courts can try the case, it is a valid agreement because you're not restraining legal proceedings. You're only telling that one of the courts can be used as jurisdiction, but you're not restraining. You're not telling you cannot file the case in any court of law. Did you understand? Yes or no?
Yes, sir.
So when Bhavna sold goods to Saharda, in the agreement it was written that if there is a dispute in the quality of goods, the case can be filed either in Mumbai High Court or Bangalore High Court. Correct or no? Because both of them were not agreeing where it should be. Now they are asking you whether that agreement between Bhavna to sell goods to Saurabh is valid or void. We will say it is valid because they are not restricting it, or if they mention over there that the court cannot try the case if there is a defect of, then it is void. Well, then it is void. Understood? Okay, go to the second question. Quickly, Bhavna.
Second one, X offers to sell his Maruti car to Y. Y believes that X has only one WagonR car and but agrees to buy it.
What? I didn't understand. Read the question.
X offers to sell his Maruti car to Y. Y believes that X has only WagonR car but agrees to buy it.
Might be this fellow has two cars, huh? That means the question is only a little odd, right? I think so. This is mistake. What this is a mistake. Just see the answer. They've not given the
No,
question
sir, it's
correct.
correct.
It's correct, sir.
Void.
Void. It's
The-
a void agreement. Why is it void? No, I'm telling you it's a mistake, right? It's a mistake of fact. What is a mistake of? Remember we did
yes, sir.
mistake. Correct
Yes,
or no?
yes.
Bilateral mistake. What bilateral? There is no
Mistake.
consensus added him. He is thinking that he wants to buy the WagonR car. That fellow is thinking he'll sell other car, Maruti Alto. Correct or no? So they both are thinking of two different things at the same time, right? So the contract is null and
Void.
Void.
it's a mistake. It's no consensus or not a mistake in the question. I'm telling the answer is there is a mistake between the two parties. Which section I forgot? Correct or no?
The said agreement is void.
Uh,
Reason, this agreement is void as the two parties are thinking about different subject
different
matters.
subjects. I don't do that. Okay, because we are running out of time. Correct or no? So you all understood
Yes.
that, right? Okay, go to the next question. Next question means that part. Right.
Last one, X, a physician and surgeon, employs Y as an assistant on a salary of 75,000 per month for a term of 2 years, and Y agrees not to practice as a surgeon and physician during these 2 years.
Absolutely valid agreement, because agreement in restraint of trade when you are doing internship or when you are doing apprenticeship is a valid agreement. What it is a valid?
Agreement.
Usually agreements in restraint of trade are null and void. They are agreements opposed to public policy. However, there are exceptions to the rule of agreements in restraint of trade. One of the exceptions is if you are working as an intern or an apprentice, you cannot practice your own trade competing with the original trade. Remember, we had done this, we had done that chart, statutory exceptions, legislative exceptions, correct or no? If you are a partner, you cannot carry on business. So agreements in restraint of trade. This is an exception to the rule of agreement in restraint of trade. So it's a valid agreement. What it is a valid agreement. So Lee, don't read the answer. We are running out of time. Okay, go to the next one.
I'll read the sixth one, sir.
Sixth question, the next question.
Huh.
These three questions are over, right? Correct?
Yes,
And
sir, done.
okay, and we'll read question number 6.
Mr. Seth, an industrialist, has been fighting a long-drawn litigation with Mr. Raman, another industrialist. To support his legal campaign, Mr. Seth enlists the services of Mr. X, a legal expert, stating that an amount of 5 lakh would be paid if Mr. X does not take up the case of Mr. Raman. Mr. X agrees, but at the end of the litigation, Mr. Seth refused to pay. Decide whether Mr. X can recover the amount promised by Mr. Seth under the provisions of the Indian Contract Act.
Read the answer quickly, because we are running out of time. I have to do Sale of Goods Act also, and I have to do Companies Act also, right? Quickly.
According to Section 27 of Indian Contract Act 1872, an agreement by which any person is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. In the instant case, Mr. Seth is in litigation with Mr. Raman since long. Mr. Seth enlists the services of Mr. X, a legal expert, stating that an amount of 5 lakhs would be paid if Mr. X does not take up the case of Mr. Raman. Mr. X agrees, but at the end of the litigation, Mr. Seth refused to pay. As Section 27 makes the contracts in restraint of trade void, the contract between Mr. Seth and Mr. X is also void. Hence, Mr. X cannot recover the amount promised by Mr. Seth.
Okay, now you all understood. Agreements in restraint of trade are not allowed. So you cannot tell a person you cannot take up a case for somebody else and I'll give you 5 lakhs. It's just like you tell a person, if you hit this person up, I'll give you 2 lakhs. Will that be valid? Suppose that fellow hits that person and comes. Will it be valid, that agreement? No, right? So any agreements in restraint of trade and profession are null and void. However, in this case, they asked you one question. So whenever you get these type of questions, write in the format which I told you. Facts of the case, they gave you the facts of the case, provisions of the law, analysis and conclusion. What provision of the law, analysis and conclusion. Understand? They've done the same thing, but they've not done it in the same order, or they've not done it in the same order. Understood? Understood? They've also summarized the case. They've also mentioned the provisions of the act, analysis of the case, etc. Right? Good. Next.
7th one. What are the consequences of the destruction of specified goods before making of contract and after the agreement to sell under the Sale of Goods Act 1930?
Now we have come to Sale of Goods Act. What is the consequence of destruction of specific goods? Okay, specified goods. What are specified goods? Anybody? Remember I told you USA, unascertained goods, specific goods, ascertained goods. Goods which are identified and separated at the time of contract of sale are called as specific goods. Goods which are not identified and separated at the time of contract of sale are called unascertained goods. Goods which are separated and identified after the contract of sale are called as ascertained goods. What are they called? Now, if there is a destruction of subject matter of the goods after an agreement to sell, but not before the sale, just read that line again. Read the question again.
Yes, sir. Just a minute. I'm scrolling down. What are the consequences of the destruction of specified goods before making of contract and after the agreement to sell under the Sale of Goods Act 1930?
Agreement to sell. When there's an agreement to sell, does the property in the goods get transferred from the seller to the buyer or no? Does the property in goods get transferred to the buyer when there is an agreement to sell, or it gets transferred only after the contract of sale?
Only after the contract of sale.
Only after the contract of sale. So now the property in the goods is with whom? Is it with the seller or with the buyer?
Seller.
So when the goods are destroyed, who will bear the loss?
Seller.
Seller will bear the loss. So here, since there is only an agreement to sell and there is not a sale, therefore, since the property in the goods has not got transferred from the seller to the buyer, the property in the goods remains with the seller, and therefore any destruction of subject matter or loss of subject matter, the loss will be borne or the risk will be borne by the seller and not by the buyer. What? It will not be borne by the
Buyer.
buyer. Understood or no?
Yes.
Correct? Read if you want to read it out quickly.
First one. Goods perishing before making of contract, Section 7 of Sale of Goods Act 1930. In accordance with the provisions of Sales of Goods Act 1930, as contained in Section 7, a contract for the sale of specific goods is void if at the time when the contract was made, the goods without the knowledge of the seller perished or become so damaged as no longer to answer to the description in the contract, then the contract is void ab initio.
Void means there's no contract. So the goods remain with the seller. So the loss will be borne by the seller. Yes or no? Yes or no? Got
Yes.
it? Yeah, that's all.
Second one, goods perishing before sale but after agreement to sell. Section 8 of the Sale of Goods Act 1930. Where there is an agreement to sell specific goods and subsequently the goods without any fault on the part of the seller or buyer perish or become so damaged as no longer to answer their description in the agreement before the risk passes to the buyer, the agreement is thereby avoided or becomes void.
Avoided because the risk has not got transferred to the buyer. Same thing, right? Correct or no? Which I told. Got it? You have to mention only section 8. The section 7, they've chumma given you, or they have simply given you, right or no?
Yes, sir.
Yes,
Yeah.
sir.
Yeah.
Eighth one, what are the implied conditions in a contract of sale by sample under the Sale of Goods Act 1930? Also state the implied warranties operative under the Act.
Oh, so they've asked you the full implied conditions as well as the implied condition has to sale by sample. What has to sale by sample? And they've asked you also implied warranties. Remember, we did the implied warranties as to quiet possession, non-existence of encumbrances, correct or no? Disclosure of dangerous nature of the goods, implied warranties, right? And we done implied
Yes.
condition also. Read the answer. This is just a revision for you.
First one, sale by sample, section 17 of the Sale of Goods Act 1930. In a contract of sale by sample, there is an implied condition that A, the bulk shall
Okay, now remember, they've asked you the implied condition, not all the implied conditions, only implied conditions within the sale of sample. What within the sale of sample? So whenever they mention what are the implied conditions as to sale by sample, you have to mention only the parts under sale of sample. You don't have to mention the whole implied condition. Implied condition as to title of goods, implied condition as to wholesomeness. Remember all those things which you have done? Merchantability. This is only for sale of sample. So what comes under sale of sample, you have to mention that. What you have to mention that, right or no?
Yes, sir.
Yes, sir.
Put on the light. Now you can see me better, right? But I'll have to close the door back. Okay, read this question, then I'll just close the doors and everything and come. Go quickly.
A, the bulk shall correspond with the sample in quality.
Bulk should correspond with the sample, right? So if you're selling 900 kgs of rice, at least 895 kg should be the same as the sample. Correct or no?
Yes, sir. B, the buyer shall have a reasonable opportunity of comparing the bulk with the sample.
Sample.
C, the goods shall be free from any defect rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. This condition is applicable only with regard to defects, which could not be discovered by an ordinary
Yeah, and
examination.
we had done so many cases for that also, no? Where you cannot discover the defects by ordinary. Yeah.
If the defects are latent, then the buyer can avoid the contract. This simply means that the goods shall be free from any latent defect, that is a hidden defect.
Defect, correct or no? Remember we did that case of the French army buying shoes, correct? And the shoes were made out of paper soles rather than of rubber soles. So they could avoid the contract, but they could avoid the contract. So these three conditions, they should be correspond with the bulk of the goods. There should be reasonable time to examine the goods. And finally, there should not be any latent defect. Or there should not be any latent means hidden defect.
Second part, the following are the implied warranties operative under the Act. First one, warranty as to undisturbed possession, section 14, subclause B. An implied warranty that the buyer...
Okay, no, don't worry about it. Just read the main headings. You all know, no undisturbed possession. Second one is implied warranty as to?
Warranty as to non-existence of encumbrances. Third one, warranty as to quality or fitness by usage of trade. Section 16, subclause 3. Sir, is it section 16 or 14? Here
16.
for non-existence of encumbrances.
No, this is 14, but this is 14, section 16 only, I think so.
Okay, sir. Fourth one, disclosure of dangerous nature of goods.
Okay, now listen here. One more thing which I want to tell you, which many students mess up. When they give you the paper, they don't give you, do they give you both the papers together, right? The business law and business correspondence and reporting together, they give you the paper, right? I'm not sure. That's why I'm a little confused with this. Do they give you the entire business law and business correspondence, or you finished business law and then they give you business correspondence, or they give you the whole paper?
Both together.
Both. Now, I want you all to decide whether you all will attempt business correspondence and reporting first, or will you attempt business law first? My suggestion is do of business correspondence and reporting first, because it gets over fast, right? Is it faster?
Yes, sir.
Yes, sir.
And it's safe also. You have a lot of marks which you can get right over there. Correct or no?
Yes, sir.
So my suggestion is safeguard yourself. Do of BCR first. It's a 3-hour paper, right? Correct or no?
Yes,
Yes.
sir.
Yes, sir.
So set aside around 1 hour for business correspondence and reporting. Finish it off. Or 1 hour, 10 minutes maximum. Actually, as for 40 marks, you should be setting aside 1 hour, 12 minutes for uh, business correspondence and reporting, and 1 hour, 48 minutes for 72 is to, yeah. But my suggestion is finish off your business correspondence and reporting in 1 hour. And if you get it before 1 hour, also okay. Then focus your time on this. Why I'm telling you this is, suppose they give you a question like this and it is 6 marks or 7 marks or something like that. Don't leave any questions unanswered in the paper saying that I don't have time. It is not that you don't have time, it's that you have not planned your time properly. What, it's not planned your time properly, correct or no?
Yes, sir.
So there are 5 questions, correct, of 12 marks each, 60 marks. So approximately you should be getting around 2 minutes per question, 2 minutes per mark. So 120 minutes if you are doing it in 1 hour. So 120 minutes means no question should take more than 20 to 25 minutes. Correct or no? So when you are writing, please, for God's sake, if it's 3 marks question or 2 marks question, what are implied warranties? Don't explain each and every implied warranty. If it's a 4 mark question, write one line about each. If it's a 6 mark question, give a little more examples also. Correct or no? So seeing the weightage of the questions and the marks, please write the answers. Correct or no? But you have to plan yourself. Your brain should work in such a way that for business law, for each question of 5 marks each, don't keep 24 minutes exactly. Keep around 21, 22 minutes. Keep 20 minutes per question. And keep looking at after each question you answer. See that you've done 20 minutes and you go on to the next question. 1 or 2 minutes will get extended here and there. That's okay. But I don't want you to leave out any question and say that, oh, I answered only 4 questions and the 5th question I could not. The moment you start leaving out questions in the exam, the chances of you passing become very, very difficult. But they become very, very, because now they are marking your paper on 88, they're marking your paper on 85, and from 85 you have to score 50 or 40 or whatever it is. Correct or no? Which is not a great, like say World Cup is going on, one team scores 350 in 50 overs. Now you are asking that other team to score the same 350 in 40 overs. 10 hours, 10 overs have been cut off. Isn't it difficult? Yes or no?
Yes.
So
Yes, sir.
please time your paper, for God's sake, because this question is a huge question. They've asked you implied condition as to sample, plus they've asked you implied warranties, right? So you'll have to time your paper and see that you do not exceed. Don't undercut also. Don't just write one line for everything and then they'll give you half marks on you. You have to be smart. What you have to be? Smart while answering the question. See the marks weightage to each question, and on that basis you will decide how much has to be written for each question. Got it? And
Yes,
keep a
Yes.
deadline of 1 hour for the first business correspondence and reporting, and keep 2 hours for business law. Or even if you take 1 hour 5 minutes, but it's always safer to keep. Let's divide 180 in the ratio 60 is to 40, 3 is to 2. 180 into 3 by 5, that is 36 into 3, 108 minutes. And okay, as I told you, 1 hour 48 minutes and 1 hour 12 minutes. But keep the 10 minutes buffer for business law. Correct or no? Understand? Squeeze out 10 minutes out of BCR and put it in business law. Got it or no?
Yes, sir.
Yes,
yes,
sir.
sir.
No.
Yes.
Mm. Let's go to the next one.
Ninth
Okay,
one.
wait. Did it close one minute? I'll just close everything and come back. Just hold on for a minute, right? Just hold on. Just hold on.
Yes, sir.
Okay. Am I audible, visible?
Yes, sir.
Okay, we can continue. So that's why I told you. So plan your paper in such a way 1 hour, 2 hours. Okay, keep that in mind. 1:2. Right. Go to the next one.
Ninth one. Shubhangi went to a jewelry shop and asked the sales girl to show her diamond necklace with sapphire stones. The jeweler told her that we have a lot of designs of diamond necklace, but with blue stones. If she chooses for herself any special design of diamond necklace with blue stones, they will replace blue stones with sapphire stones. But for
Hey, wait, just hold on. No, 1 minute, just hold on. Yeah. Just 1 minute, just one. Just go ahead, read, Bhavna. I didn't understand the sapphire stone and blue stone, that I was getting confused with the reading. Just read
shall
it again.
I read from the first, sir?
Yeah, read from first again.
Shubhangi went to a jewelry shop and asked the sales girl to show her diamond necklace with sapphire stones.
Hey, sapphire is which color? Yeah, red.
No, sir, kind of golden yellow will get it.
Golden yellow. Because I didn't know. That's why I'm getting concerned with the blue and sapphire. Sapphire is yellow color. Pakka.
Yes, sir, golden yellow kind thing.
Emerald is green, I know. Which is blue then? Opal.
Torque, torque, yes, sir. Okay. From
Torque.
T something, sir. Yeah, sir.
Okay. Sapphire is golden, emerald is green, ruby is red, I know.
Yes, sir.
Blue, we don't know. Okay, we continue, read.
The jeweler told her that we have a lot of designs of diamond necklace, but with blue stones. If she chooses for herself any special design of diamond necklace with blue stones, they will replace blue stones with sapphire stones.
Okay.
But for the sapphire stones, they will charge some extra cost. Shubhangi selected a beautiful designer necklace and paid for it. She also paid the extra cost of sapphire stones. The jeweler requested her to come back a week later for delivery of that necklace. When she came after a week to take delivery of necklace, she noticed that due to sapphire stones, the design of necklace had been completely disturbed. Now she wants to terminate the contract and thus asked the manager to give her money back, but he denied for the same. Answer the following questions as per the Sale of Goods Act 1930. First sub-question, state with reasons whether Shubhangi can recover the amount from the jeweler. Second one, what would be your answer if jeweler says that he can change the design, but he will charge extra cost for the same?
Okay, read the answer. I'll go to this. I'll explain this once you finish reading the answer.
As per section 43 of as per section 4 subclause 3 of Sale of Goods Act 1930, where under a contract of sale, the property in the goods is transferred from the seller to the buyer, the contract is called a sale. But where the transfer of property in the goods is to take place at a future time or subject to some condition thereafter to be fulfilled, the contract is called an agreement to sell. And as per section 4 subclause 4, an agreement to sell becomes a sale when the time elapses or the conditions are fulfilled subject to which the property in the goods is to be transferred.
This you know. Okay. Then.
First sub-question, on the basis of above provisions and facts given in the question, it can be said that there is an agreement to sell between Shubhangi and jeweler and not a sale. Even though the payment was made by Shubhangi, the property in goods can be transferred only after the fulfillment of conditions fixed between the buyer and the seller. As due to sapphire stones, the original design is disturbed, necklace is not in original position. Hence, Shubhangi has right to avoid the agreement to sell and can recover the price paid. Second sub-question, if jeweler offers to bring the necklace in original position by repairing, he cannot charge extra cost from Shubhangi. Even though he has to bear some expenses for repair, he cannot charge it from Shubhangi.
Correct. So you understood this? See, now what is a sale? Sale is when there's a transfer of property from the seller to the buyer. What is an agreement to sale? When the seller agrees to transfer the property to the buyer at a future date, either on a specified time or on the fulfillment of certain conditions. What, or on the fulfillment of certain
Condition.
conditions. So suppose you gave a shirt, you told a person, see, this shirt is there, blue color shirt. Can you make a black shirt of the same design? But he makes the black shirt of a different design. Will you buy it?
No,
No.
sir.
No, because the condition is in the same way when Miss Shubhangi chose the jewelry design and she asked the blue stones to be replaced by yellow stones or the sapphire stones, she wanted that design. But since he made it in a different design, the design was changed. The condition has not been satisfied. So if the condition is not been satisfied, the agreement to sell will never become a sale. What, it will never become a sale. So if there is no sale, the property in the goods is not transferred from the seller to the buyer. So the buyer has every right to refuse the goods. And if he tells, no, I'll pay it, you pay me 5,000 extra, I'll repair it. Why should you pay? Because the original condition was that I paid already extra. I wanted the same design with different stones, but you changed the design. So since you changed the design, you are not going to pay him anything extra. What, you're not going to pay him anything
Extra.
extra. Understood or no? Yes?
Yes, sir.
Yes, sir.
Yes.
Hmm.
10th one, state the various essential elements involved in the sale of unascertained goods and its appropriation as per the Sale of Goods Act 1930.
Okay, this I've already discussed with you. Remember, unascertained goods, correct? The property in the goods has not got transferred. Unless the goods become ascertained, will the property in the goods get transferred from the seller to the buyer? It will not get transferred from the seller to the buyer, correct or no? So can we skip this question? You will be able to read this in this thing, right? Is that okay with you all? Or you want to read it off? Read how many points are there? Quickly.
Just a minute, sir.
Hmm.
Sir, we have from point A to point G, sir. Like it is in a single statement.
Single statement. This is the points to be transferred in ascertained goods. Hmm.
Yes, sir. Sale
Sir,
of
we will
What you will? What she saying?
read later, sir.
Okay, she'll read later. Okay, we'll go to the next question, Bhavna.
yes, sir.
Hmm.
Uh, 11th one, Mrs. Kanchan went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price of the same as rupees 125 per kg, to which she agreed. Mrs. Kanchan insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon such purchase. The shopkeeper showed her a bowl of rice as sample. The sample exactly corresponded to the entire lot. Mrs. Kanchan examined the sample casually without noticing the fact that even though the sample was that of basmati rice, but it contained a mix of long and short grains. The cook, on opening the bags, complained that the dish, if prepared with the rice, would not taste the same as the quality of rice was not as per requirement of the dish. Now, Mrs. Kanchan wants to file a suit of fraud against the seller, alleging him of selling a mix of good and cheap quality rice. Will she be successful? Decide the fate of the case and options open to Mrs. Kanchan for grievances redressal as per the provisions of Sale of Goods Act 1930.
Okay, read it.
What would be your answer in case Mrs. Kanchan specified her exact requirement as to length of rice?
Okay, now listen here. See, if you all are getting confused, what is the answer for the case? Correct or no? I'll give you one hint. Okay. Always read the whole question. Okay. Now you all don't know who's wrong. Yeah, Kanchan is wrong or shopkeeper is wrong. We are not able to understand only. This is sale by sample, but one is short, one is long. So I think so. Mrs. Kanchan is correct. Oh, so she can file a case. Oh, or is the shopkeeper correct because he showed her sample? Now you're not able to decide. Whenever you're not able to decide the answer for a particular case study, read the last question where they ask you something else. What did they ask you? Read the last line which you read now. What would your answer be? Read the question now, no? Bhavna?
Yes, sir. What would be your answer in case Mrs. Kanchan specified her exact requirement as to the length of rice?
Right. That means who's wrong now? It's Kanchan wrong. No, if she would have exactly specified a quantum of rice, then the shopkeeper is wrong, right? That means you know that the first question, this Kanchan is wrong. What Kanchan is?
Wrong.
Correct or no? So by reading the question, see even the previous question, what would your answer be if the jeweler asked extra money? That means he is wrong. He cannot ask extra. So whenever you're confused, they will always give you a clue by asking another question. So you will know the correct answer. What you will know the correct? Understood what I'm trying to tell you? Correct or no? So here, Mrs. Kanchan specified sale by sample basmati rice. The basmati rice is correct. It's short and long grain. And the sample is matching. What are the conditions for sale by sample? One, bulk of the good should match the sample. Is it matching the sample? Yes. Correct or no? She got reasonable type to inspect. Yes or no? Yes. There is no latent defect because she got the same sample which she asked for. Correct or no? But if she would have specified, I want basmati long grain rice, and then he would have given a long and short range, she has every right to rescind the contract. That is sale by sample and description. What sale by sample and description? But here, since she did not specify that she wants only long grain basmati rice, she has no legal remedy against the shopkeeper. What she has no legal remedy against the. So whenever you are confused, read the whole question and see the question which they've asked after that. When they read the question after that, you will get a hint which is whether this one is correct or yes or no. Got it?
Yes, sir.
Yes.
Always do that, right? So you all will not get confused what to answer, correct? Even though you think one answer is there. So whenever they give you a side question, what would you decide if this would have happened? Then you have an option. What you have an okay? Read quickly. Read the answer, heroine.
As per the provisions of subquestion 2 of section 17 of the Sale of Goods Act 1930, in a contract of sale by sample, there is an implied condition that bulk shall correspond with the sample in quality. The buyer shall have a reasonable
Reasonable time.
opportunity of comparing the bulk with the sample. In the instant case, in the light of provisions of subclause B of subsection 2 of section 17 of the Act, Mrs. Kanchan will not be successful as she casually examined the sample of rice which exactly corresponded to the entire lot without noticing the fact that even though the sample was that of basmati rice, but it contained a mix of long and short grains. Second one, in the instant case of Mrs. Kanchan, does not have any option available to her for grievances redressal. Last one, in case Mrs. Kanchan specified her exact requirement to the length of rice, then there is an implied condition that the goods shall correspond with the description. If it is not so, the seller will be held liable.
That's what I told you, sample and description. So if it's sample and description, it should match both the sample as well as the description. Got it or no? Well, understood how to tackle these questions, correct? We are doing so many case laws and so many case laws come in the exam. That's why we are doing it. Remember, out of 60 marks, you have around 24 to 28 marks which come through. I think so.
Yes,
24. Yeah. So you will have to be very, very careful while doing the paper, right? Yes.
12th one, Ravi sold 500 bags of wheat to Tushar. If each bag contains 50 kilograms of wheat, Ravi sent 450 bags by road transport and Tushar himself took remaining 50 bags. Before Tushar receives any delivery of 450 bags sent by road transport, he becomes bankrupt. Ravi, being still unpaid, stops the bags in transit. The official receiver on Tushar's insolvency claims the bags. Decide the case with reference to the provisions of Sale of Goods Act 1930.
Rights of an unpaid seller, remember? What are the rights of an unpaid seller? Right of stoppage in transit. What right of stoppage in?
Transit.
So if the buyer becomes insolvent and the goods are still in transit, correct or no? The seller has every right to stop the goods in transit. The official receiver is the person who's acting on behalf of. Okay, just hold on, no, 1 minute. Just hold on.
Yes.
Okay. Am I audible and visible?
Yes, sir.
Yes.
So you have to understand that the official receiver is the person who's the uh, representing the buyer. The buyer has become insolvent, so the court will appoint an official. Now, this official receiver shilling, you can't stop this 450 bags. This belongs to me because I've already sold the goods. But as per the rights of an unpaid seller, if the buyer becomes insolvent, the seller has every right. So the official receiver has no right to retain the 450 bags. The 450 bags can be called back by the seller, even though Tushar has taken 50 bags. Even if part delivery has been taken, the remaining part delivery can be stopped by the seller if he's unpaid. So there are conditions to be satisfied for an unpaid seller when there is right of stoppage in transit. One, the seller is unpaid. Second, the buyer becomes insolvent. Third, the goods are still in transit. What the goods are still in
Transit.
transit. Correct or no? Now, since all these three conditions are satisfied, who can stop the goods in transit? The seller can stop the goods in transit. The
Right.
official receiver will have no right to take the. Okay. Right. Go ahead. Go ahead. Read.
Shall I read the answer or 13th question, sir?
Read of the answer quickly. Cases we'll finish off quickly. Now we have half
Yes,
an
sir.
hour more. After this, we'll do Companies Act only. What is the 13th question? Is Companies Act? Huh?
Don't know, sir. I'll check it.
Okay. Wait. This is RTP 2023 only, no? December.
Yes, sir.
Yeah.
Yes, sir.
I'll read out the answer first.
Yeah.
Right of stoppage in transit, Section 50 of the Sale of Goods Act 1930. Subject to the provisions of this act, when the buyer of goods becomes insolvent, the unpaid seller who has parted with the possession of the goods has the right of stopping them in transit. That is to say, he may resume possession of the goods as long as they are in the course of transit and may retain them until paid or tendered price of the goods. When the unpaid seller has parted with the goods to a carrier and the buyer has become insolvent, he can exercise this right of asking the carrier to return the goods back or not to deliver the goods to the buyer. In the instant case, Tushar, the buyer, becomes insolvent and 450 bags are in transit. Ravi, the seller, can stop the goods in transit.
And stop the goods in transit. Okay.
Can stop the goods in transit by giving a notice of it to Tushar. The official receiver on Tushar's insolvency cannot claim the bags.
Cannot claim the bags. Got it or no? Right. Okay. Done. Now let's go to the next. What's the next question? 13th.
Sir, it's from Indian Partnership.
Go.
Three sub questions we have.
No, leave that Indian Partnership. Go to companies. Limited liability comes in your exam only for 5 marks. Companies Act is the next. So we finished Sale of Goods Act. We have finished Indian Contract Act. Now we are going to. So now you are getting a gist of how the paper will, how the questions will come in the exam. Yes or no?
Yes, sir.
Yes,
Yes,
sir.
sir.
So there's only one question regarding companies and
Only one?
last question.
Okay, read it out. And then that's all. The chapter is over. The question paper is over.
Yes, sir.
Okay, then what we'll do is from the previous revision test paper, we'll see other company act questions. Yes or no?
Yes.
If there are any case studies and all, right or no? There are no case studies in
Sir,
this?
there are 2 questions of company act.
Who's telling this? What's your name?
Sir.
Huh?
Anuhya.
Okay.
Question number 19 and question number 20 are from companies act.
Question number 19 and question number?
20, sir. The last two.
Okay, let's finish these two and then we'll see if we can do from there.
Yes, sir. 19th one, BC Private Limited and its subsidiary KL Private Limited are holding 90,000 and 70,000 shares respectively in PQ Private Limited. The paid up share capital of PQ Private Limited is 30 lakh, which is 3 lakh equity shares of rupees 10 each, fully paid. Analyzed with reference to provisions of the Companies Act 2013, whether PQ Private Limited is a subsidiary or of BC Private Limited. What would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC Private Limited in PQ Private Limited?
Okay, now anybody can tell me what is the definition of holding and subsidiary company when I did it with you? When one company along with its subsidiaries holds more than 50% of the shares of another company, then it becomes a subsidiary. Now read the question carefully. Read it very carefully. Read it again, Bhavna. 1 minute. Read the question.
From the start, sir.
The whole question again you read.
Yes, sir. BC Private Limited and its subsidiary.
Okay, now which is the main company? BC Private Limited.
BC.
Okay.
And its subsidiary KL Private Limited.
KL Private Limited. So BC is the main company. It has a subsidiary called KL Private Limited. Understood this? Now,
Yes.
whenever they give you names like BC, KL and all, that is simply to confuse you. Because you are used to A, B, C, X, Y, Z. They'll purposely give you BC, KL, RN. That is psychology. Because when you read the question, you'll get confused. But don't get confused. Correct or no? Understood? Yeah.
Yes. KL Private Limited are holding 90,000 and 70,000 shares respectively.
Okay, 90 and 70. So how much is BC holding? 90,000.
90.
How much is KL holding?
70,000.
70. Now how much is 90 plus 70?
160.
1,60,000. Okay. Keep this in mind. Okay. Read on.
The paid up share capital of PQ Private Limited is 30 lakhs. That is 3 lakhs equity share of rupees 10 each, fully paid.
So how much is 50% of 3 lakhs?
1 lakh.
1,50,000.
Now is this they are holding more than 1,50,000 shares or less than 1,50,000?
Yes,
Huh? Who? 90 plus 70 is 1,60,000. That's more than 1,50,000. No, who told less?
Yes, sir. More.
Now, if a company along with its subsidiary holds more than 50% of the voting power or share capital of another company, then what happens? Then PQ Limited also becomes a subsidiary of BC Limited. Yes or no?
Yes, sir.
Yes.
Yes or no? Hmm.
Yes, sir.
Yes, correct. Go ahead. Now continue reading, Bhavna.
Analyze with reference to provisions of the Companies Act 2013 whether PQ Private Limited is a subsidiary of BC Private Limited.
Of course,
would
it is a BC. Now, suppose they would have asked, analyze whether PQ Private Limited is a subsidiary of BC Limited and KL Limited. Is it a subsidiary of KL or is it a subsidiary of only BC?
Only BC, sir.
Only BC, because KL is not with its subsidiaries is holding. Correct or no? Yes. So it's only of BC. Correct or no? Okay. Then second part.
What would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC Private Limited in PQ Private Limited?
Even then, BC Limited will be a subsidiary. Why? Because the court, the law says when a company, along with its subsidiaries, holds more than 50% of the
50%.
share capital. So BC plus KL is more than 1,50,000, right or no?
Yes, sir.
Yes, sir.
So definitely here PQ Limited will be a subsidiary of both KL as well as BC. What of KL as well as
BC.
BC.
in the first case it was only a subsidiary of BC.
BC.
Correct or no? In the second case it will be a subsidiary of both BC and
KL.
understood.
Yes, sir.
Yes.
Yeah,
Yes,
let
sir.
her read the answer. Let her read the answer.
Section 2, subsection 87 of the Companies Act 2013 defines subsidiary company in relation to any other company, that is to say the holding company, means a company in which the holding company, first one, controls the composition of the board of directors or exercise or controls more than one half of the total voting power, either at its own or together with one or more of its subsidiary companies.
Now remember, whenever you get these type of questions, I have to explain crudely, but first you have to give definition of holding company and then you have to analyze the case. Remember, facts of the case, provisions, analysis, conclusion. Yes or no? So when you are
Yes.
giving the provisions, you have to give the definition of a holding company. What you have to give the definition of a holding
Company.
You cannot just simply chumma tell something. Correct or no? Right? Yeah.
For the purpose of this section, first one, a company shall be deemed to be a subsidiary company of the holding company, even if the control referred to in subclause 1 or subclause 2 is of another subsidiary company of the holding company. Second one, layer in relation to a holding company means its subsidiary or subsidiaries. In the instant case, BC Private Limited together with its subsidiary KL Private Limited is holding 1,60,000 shares, which is 90,000 plus 70,000 respectively, which is more than one half in nominal value of the equity share capital of PQ Private Limited. Hence, PQ Private Limited is subsidiary of BC Private Limited.
Definitely. And see the second question. This is already I told you, right? Second point.
Second part. In the second case, the answer will remain the same.
Remain the same. That means still.
KL Private Limited is holding 1,60,000 shares, that is more than one half in nominal value of equity share capital of PQ Private Limited, that is holding more than one half of voting power. Hence, KL Private Limited is holding company of PQ Private Company and BC Private Limited is a holding company of KL Private Limited. Hence, by virtue of the same relationship, BC Private Limited becomes the holding company of PQ Private Limited.
Understand, no? Right or no?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Good. Very good. Right.
20th question. The last one. Narendra Motors Limited is a government company. Shah Auto Private Limited have share capital of rupees 10 crore in the form of 10 lakh shares of rupees 100 each. Narendra Motors Limited is holding 5,05,000 shares in Shah Auto Private Limited. Shah Auto Private Limited claim the status of government company. Advise as legal advisor whether Shah Auto Private Limited is government company under the provisions of Companies Act 2013.
Now, when you see this question, you'll say, aha, it's holding more than 50%. But remember, government company is 51%. It is not 50%, right? When the government company holds more than 51%, remember the definition of government company? Yes or no?
Yes, sir.
So here
Yes.
they are holding 5,05,000 shares. Instead of, if they would have had 5,10,000 shares, it would have become.
Government company.
Government.
But since you are holding more than 50%, it can be a subsidiary, but it cannot become a government company. What it cannot become a government company, because in government company the rule is 51%. What the rule is
51%.
51, not 50%. Yes or no? For other subsidiary companies, it is 50%. So she'll read out the answer. You will get the answer. Government company. Read on. Yes, go ahead, Bhavna.
According to the provisions of Section 2, subsection 45 of Companies Act 2013, government company means any company in which not less than 51% of paid
Not less than 51%. 51. Okay.
51% of paid up share capital is held by first one, the central government or
State government.
by any state government or governments, or partly by the central government and partly one or more state governments. And the section includes a company which is subsidiary company of such a government company. According to Section 2, subsection 87, subsidiary company in relation to any other company, that is to say the holding company, means a company in which the holding exercises or controls more than one half of the total voting power, either at its own or together with one or more of its subsidiary companies. By virtue of provisions of Section 2, subsection 87 of Companies Act 2013, Shah Auto Private Limited is a subsidiary company of Narendra Motors Limited because Narendra Motors Limited is holding more than one half of the total voting power in Shah Auto Private Limited. Further, as per Section 2, subsection 45, a subsidiary company of government company is also termed as government company. Hence, Shah Auto Private Limited, being subsidiary of Narendra Motors Limited, will also be considered as government company.
Hey, how is this? It should not be, no, more than 51%, right? They've given a wrong answer, right? Read that provision, Section 2, subsection 45 again.
As per Section 2, subsection 45, a subsidiary company of government company is also termed as government company.
No, leave that. Read the Section 2, subsection 45. Not the what they have written. Read the one which they've given in the definition. Read the whole definition of Section 2, subsection 45, Bhavna.
So, like, which is given in study material, you're asking?
No. In this only they gave 2 section 45, then they gave section 2, section 87, right? I want you to read the definition which they gave for section 245, 2 paragraphs above what you read just now. Savarda, you just see definition of government company.
Section according to the provisions of Section 2, subsection 45 of Companies Act 2013. Government company means any company in which not less than 51% of paid up share capital is held by the central government or by state government or governments, or partly by the central government and partly by one or more state governments. And the section includes a company which is a subsidiary company of such a government company.
So we made a mistake. Correct or no? So here the government should hold more than 51%, but if the government company holds more than 50% and it has a subsidiary company, then the subsidiary company also becomes a government company. Okay, so we did a mistake. Okay, sorry guys. So remember that the central government or state government or both should hold more than 51% in a government company. But if that government company holds then more than 50% in another company, then the subsidiary company also becomes a government
Company.
Company. Understood or no? So that 51% applies only for central government and state
Government.
government. It does not apply for government companies. So if a government company is holding even 50.1%, then the subsidiary company is considered a government company. What is considered as a government? Got it? Yes or no?
Yes,
Yes,
sir.
sir.
Yes.
Yes,
Okay.
sir.
It is a small mistake. Okay. Doesn't matter. Okay. So this ends your revision test paper where we've discussed that.
December 2020.
Okay. Any doubts you'll have? Or you'll want to do, you want to do one or two more questions of Companies Act? We've done only two. You want to go to the previous paper? Just go to the previous paper and see Company Act questions quickly, because we've done six questions of Sale of Goods Act and
11 to 12 questions of Indian contract.
Correct. Yeah. We've done 12 questions. So Indian Contract Act is very huge, right? Correct.
Yes, sir.
So just go to the previous paper, Bhavna, and see some questions of Companies Act. We have only 10 minutes left. We can do one or two more questions of Companies Act and then we'll wind up. Right or no?
Yes, sir.
Because we've done a lot of questions of Sale of Goods Act and Companies Act. Indian Contract Act.
Sir, 17th we have companies.
17th question, huh?
Yes, sir.
Just see how many. Okay, we'll read one or two questions and we'll see. 17th, then 18th. Huh?
17th and 18th, 19th, 20.
Oh, this one has more. Huh? But we won't be able to discuss. All are case studies or some are case and some are.
So 3 are kind of case studies, and last one is explain the classification of companies on basis of control as per Companies Act.
Okay, that you don't have to do. That you all can read on your own, right? Correct or no? So the 17, 18, just read it off quickly. The questions, we'll see if we can answer it without actually wasting time, without you reading the answer.
17th one, in the Flower Fans Private Limited, there are only 5 members. All of them go in a boat on a pleasure trip into an open sea. The boat capsizes.
Capsizes means it turns ulta. Okay.
And all of them died being drowned. Explain with reference to the provisions of Companies Act 2013. First sub question, is Flower Fans Private Limited no longer in existence?
Is it no longer in existence? Can anybody tell me?
It is still in existence.
Why? Because
Perpetual succession.
a company, perpetual succession. A company has a separate legal entity distinct from its shareholders or members.
Members.
Yeah, so it is still in existence. Second one.
Further, is it correct to say that a company being an artificial person cannot own property and cannot sue or be sued?
It can own property,
No.
it can be sued. Correct or no?
Yes.
It can own property.
Yes.
Remember we did that case, correct or no?
Yes, sir.
Where that person takes an insurance, correct or no? Northern Indian Assurance, and he took it in his name and not in the company's name, and the companies, they could not give him insurance because it was not taken in the company. So a company can own its own property and it can be sued and it can sue. Correct or no? Right.
Yes, sir.
Yeah. Lease versus Leaf Air Farming Company Limited, where the company was sued to pay compensation to the widow of the person, right? Okay, that's all right.
Yes, sir.
Okay, we won't read the answers because, correct or no? You all understood this, right?
Yes.
Yes.
Yeah. Let's go to question number 18.
18th one, ABC Limited was into sale and purchase of iron rods. This was the main object of the company mentioned in the Memorandum of Association. The company entered into contract with Mr. John for some finance related work. Later on, the company repudiated the contract as being ultra wires. With reference to the same, briefly explain the doctrine of ultrawires under the Companies Act 2013. What are the consequences of Ultrawires Act? Of the
So you have to explain, doctor, anything outside the memorandum of association will be declared null and void. Correct or no?
Yes, sir.
Yeah.
Sir.
Okay, you can read the answer for this because we have 5 minutes. Quickly read off the answer for this, Bhavna.
Doctrine of ultrawires. The meaning of the term ultrawires is simply beyond their powers.
Power.
The legal phrase ultrawires is applicable only to acts done in excess of the legal powers of the doers. Of the doers, this presupposes that the powers in their nature are limited. It is a fundamental rule of company law that the objects of a company, as stated in its memorandum, can be departed from only to the extent permitted by the Act. Thus far and no further. In consequence, any act done or a contract made by the company which travels beyond the powers not only of the
Okay, leave that. You understood, no? That's a doctrine of ultrawires, right or no? Did you all understand it, right? What is doctrine of ultrawires? We've done this in detail, right? We did the
Yes.
case also, Ritchie versus that Ashbury Railway Carriage Company Limited, remember?
Yes, sir.
Yeah.
Yes, sir. Yes.
Next one.
Next question or next para, sir?
What's the next para? Read.
The impact of doctrine of ultrawires is that a company can neither be sued or
Be sued,
ultrawires
yeah. Unless there are two exceptions, doctrine of constructive notice and correct or no? Indoor management, correct? Okay, leave that. That's all, no? They've not mentioned anything else, right?
And the last sentence they have given that hence in the case ABC Limited cannot enter into a contract.
Yeah, because it was for finance activities, correct or no? But however, if it is mentioned in the subsidiary objectives, it can. Suppose it's taking loan to buy iron rods, it is a valid contract, correct or no? Because it's supporting the purchase of iron rods, correct or no? But it starts doing separate finance business, it is considered as ultra wires. Got it or no? So you have to be very careful when you're reading it. Got it? Okay, let's read the last question for the day. 19th.
Sir, we have class till 7:30, no, sir?
No, only till 7, no? They told me.
No, sir, 5 to
7:30.
7:30.
Who told you?
Like we got the timetable like that only. 5 to 7:30, 2.5 hour class.
Is it? Oh, I thought it was only till 7. Oh God. Okay. That's why I was hurrying up. Then you aram se read. Correct or no? I didn't know. I thought that you have it only till 7. She told me from 5 to 7. Okay, then once we finish this, the company that, then we'll go to the other one. We'll go to Sale of Goods Act and we'll go backwards. This paper we'll do backwards, right or no? Right?
Yes, sir.
Yes, sir.
Yeah.
19th,
Every day you're having 2.5 hours for the distinct classes.
Yes.
not like that, sir. Like they have specified times. Like for accounts, one day we had 1.5 hour class, one day we had 3 hour class.
And for mail, sir?
Mail, sir, it was
2 hours.
only 2 hours.
2 hours.
7 to 9 morning.
That's what she told me, 5 to 7. She didn't say 5 to 7:30. It's okay, we'll do it, whatever you all want. I thought it was 5 to 7. That's why I was hurrying up. Anyway, read. Aram se read.
Yes, sir. 19th one. Articles of Association of XYZ Private Limited provides that Board of Directors, which is BOD, can take the loan up to 5 lakh for company by passing the board resolution. In that case, the loan amount is in excess of the limit. Special resolution is required to be passed in general meeting. Due to urgent needs of funds, BOD applied for loan in a reputed bank for rupees 10 lakh without passing the resolution in the general meeting. BOD gave an undertaking to bank that special resolution has been passed for such loan. The bank, on believing on such undertaking, lent the money. On demanding the repayment of loan, company denied the payment as act was ultrawires to company. Kindly advise.
Okay, this is an exception to the law of Doctor of Annavan. Remember, we did Doctor of Indoor Management, correct or no? Does a person outsider know whether all the procedures have been followed or not? Remember, we did that course, Royal British Bank versus Turquoise. It's also called Turquoise rule. Yes or no?
Yes, sir.
So in this case, the bank has every right to take back the money because the bank assumes that all the necessary procedures have been followed within the company for the loan to be sanctioned. The bank cannot send a representative by pipe and see whether the company has passed its special resolution or not, because the company gave an undertaking that it has passed the special resolution. Yes or no? Right?
Yes, sir.
Yeah. So she'll read out the answer. Aram se you read now.
According to doctrine of indoor management, persons dealing with the company are presumed to have read the registered documents and to see that the proposed dealing is not inconsistent therewith, but they were not bound to do more. They need to inquire into the regularity of internal proceedings as required by memorandum and articles. This was also decided in the case of Royal British Bank versus Turquoise.
Hmm.
In
That's
the
all.
case, XYZ Private Limited have taken loan from reputed bank for rupees 10 lakh by passing board resolution, while special resolution was necessary for such amount. BOD gave an undertaking to bank that special resolution has been passed for such loan.
Hmm.
The bank, on believing on such undertaking, lends the money. On demanding the repayment of loan, company denied the payment as act was ultra vires to company. On the basis of provisions of doctrine of indoor management,
Hmm.
the bank can claim the amount of his loan from the company. The bank can believe on the undertaking given by board and no need to inquire further.
That's all. Right? Understand? So
Yes.
they can claim the role. They assume that all the procedures have been carried out. Got it?
Yes, sir.
You want to go to the next one, Sale of Goods Act? In this paper, this is which paper are we doing? May 23, yeah?
June 23, sir.
June 23, right? So we finished December 23. Now we are doing June 23. We finished the Companies Act part, right? Now go to the sale of goods, because partnership and limited liability partnership anyway may also will do, right? Till then you just scroll on top. I'll come back in 2 minutes. Correct or no?
Yes, sir.
Give me. Okay, guys, we'll continue. Bhavna, you can continue.
Yes, sir.
Hmm.
Avyuk purchased 100 kgs of wheat from Bhaskar at rupees 30 per kg. Bhaskar says that wheat is in his warehouse in the custody of Kishore, the warehouse keeper. Kishore confirmed Ayub that he can take the delivery of wheat from him, and till then he is holding wheat on Avyuk's behalf. Before Avyuk picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now Avyuk wants his price on the contention that no delivery has been done by seller. Whether Avyuk is right with his views under the Sale of Goods Act 1930.
He is not right, right? Remember, this is called constructive delivery, or remember constructive delivery when the warehouse keeper, when the delivery is done not by physical transfer, but when the person who's holding, the third party is holding the goods, tells the buyer that he's holding the goods on his behalf and not on behalf of the seller, the delivery has been done. What the delivery has been? Correct or no? So
Yes, sir.
since here the warehouse keeper Kishore informed Ayub that he has already holding the goods on his behalf, the delivery is considered to be done through constructive delivery. What it's done through constructive delivery. Therefore, the property in the goods has passed to the seller, buyer, and now the buyer has to bear the loss. You can read the answer.
As per the provisions of the Sale of Goods Act 1930, there are three modes of delivery. First one, actual delivery. Second one, constructive delivery. And third one, symbolic delivery. When delivery is affected without any change in the custody or actual possession of the things, it is called constructive delivery or delivery by acknowledgement. Constructive delivery takes place when a person is in possession of goods belonging to seller, acknowledges to the buyer that he is holding the goods on buyer's behalf. On the basis of above provisions and facts, it is clear that possession of wheat has been transferred through constructive delivery. Hence, Avyukt is not right. He cannot claim the price back.
Yes, he cannot claim the price back. This we discussed just now. Constructive delivery has been done, or delivery by acknowledgement. Next one. Yes.
Next one, eighth question. Priyansh orders an iron window to an iron merchant for his
Merchant.
new house. Iron merchant sends his technician to take the size of windows. The technician comes at the site and takes the size of area where window to be fitted. Afterwards, iron merchant, on discussion with his technician, intimates Priyansh that cost of window will be 5,000 and he will take 1,000 as advance. Priyansh gives 1,000 as advance and rest after fitting of window. After 3 days, when technician tried to fit the window made by him at the site of Priyansh, it was noticed that the size of window was not proper. Priyansh requests the iron merchant either to remove the defect or return his advance. Iron merchant replies that the window was specifically made for his site and the defect cannot be removed, nor can it be of other use. So he will not refund the advance money. Rather, Priyansh should give him the balance of 4,000. State with reason under provisions of Sale of Goods Act 1930 whether Priyansh can take his advance back.
Can anybody tell me whether he can take his advance back?
Yes, sir.
Why?
Because the merchant didn't give him what he wanted.
Correct. The goods should be of merchantable quality, right? If they are not given as per the specification, there is a violation of implied condition and the contract becomes null and void, right? And yeah. Okay, you can read the answer, Bhavna.
By virtue of provisions of Section 16 of the Sale of Goods Act 1930, there is an implied condition that the goods should be in merchantable position at the time of transfer of
Merchantable
property.
quality, right?
Sometimes the purpose for which the goods are required may be ascertained from the facts and conduct the parties to sale, or from the nature of description of the article purchased. In such a case, the buyer need not tell the seller the purpose for which he buys the goods. On the basis of above provisions and facts given in the question, it is clear that as window size was not proper, window was not in merchantable condition. Hence, the implied condition as to merchantability was not fulfilled. And Priyansh has the right to avoid the contract and recover his advance money back.
Correct. Wonderful. Go to the next one.
Ayushman is the owner of residential property situated at Indraprastha Marg, New Delhi. He wants to sell this property, and for this purpose, he appoints Ravi, a mercantile agent, with a condition that Ravi will not sell the house at a price not less than 5 crores. Ravi sells the house for 4 crores to Mudit, who buys in good faith. Ravi misappropriated the money received from Mudit. Ayushman files a suit against Mudit to recover his property. Decide with reasons, can Ayushman do so under the Sale of Goods Act 1930?
What a stupid thing they gave. Property doesn't come under Sale of Goods Act, right? It's not a movable property, right?
Yes.
The sale of
Yes, sir.
Residential properties.
huh?
Residential properties.
Residential property. They've done a mistake in the question. So sometimes in RTP they give question. Assuming to be a big car or something like that, okay, and do it. He can recover, right? The money because it was the mudit will get good if a person buys in good faith and he doesn't know that the person is acting in an malified intention, then he will get a good faith. But the real owner can recover the money from the person. Remember, this is the exception to the rule of contract, which says that a seller without a good title, a buyer of goods without a good title can also get a good title. What can also get a good title? Remember, this is an exception to the rule. When there is a sale by a mercantile agent, and if the buyer buys it in good faith, then the buyer will get a good title. But however, the original seller can recover the money from the mercantile agent. But he can recover the money from the mercantile agent. Understand or no? Read the answer.
As per the provision to section 27 of the Sale of Goods Act 1930, a sale made by a mercantile agent of goods would pass a good title to the buyer in the following circumstances.
Pass a good title.
Namely,
but the question is wrong. It shouldn't be residential property. It should be something else, correct? So we are changing it to a fancy car or something like that. Correct or no?
A, if he was in possession of the goods or documents with the consent of the owner. B, if the sale was made by him when acting in the ordinary
course of business,
as
correct?
a mercantile agent. And if the buyer had acted in good faith and has at the time of contract of sale no notice of the fact that the seller had no authority to sell.
That's all.
On the basis of above, it can be said that Ravi, the mercantile agent, sells property to Mudit, who bought it in good faith. Mudit obtained a good title of that residential property. Hence, Ayushman cannot recover his property from Mudit. Rather, Ayushman can recover his loss from Ravi.
He can recover it from the mercantile agent, but he cannot recover it from the buyer. He cannot recover it from the buyer. I already told you this. Got it or no? But they're giving all wrong questions. Property and all. Go ahead, next one.
Next one, 10. A agrees to sell certain goods to B on a certain date on 10 days credit. The period of 10 days expired and goods were still in the possession of A. B has also not paid the price of the goods. A becomes insolvent. A refuses to deliver the goods to exercise his right of lien on the goods. Can he
A
do-
becomes insolvent.
B?
B becomes insolvent, right?
Yes, sir.
Okay.
B becomes insolvent. A refuses to deliver the goods to exercise his right of lien on goods. Can he do so under the Sale of Goods Act 1930?
Of course, he can do it, right? Remember, when the buyer becomes insolvent or is not paid for the goods, and if there is an unpaid seller, he can exercise the right of lien to goods. If he's not parted with the goods, he can definitely exercise the right of lien. What he can exercise the right of lien, right? Go ahead, read.
Lien is the right of a person to retain possession of the goods belonging to another until claim of the person in possession is satisfied. The unpaid seller has also right of lien over the goods for the price of the goods sold. Section 47, subsection 1 of Sale of Goods Act 1930 provides that the unpaid seller who is in the possession of the goods is entitled to exercise right of lien in the following cases. First one, where the goods have been sold without any stipulation as to credit. Second one, where the goods have been sold on credit but the term of credit has expired. Third one, where the buyer has become insolvent even though the period of credit has not yet expired. In the given case, A has agreed to sell certain goods to B on credit of 10 days. The period of 10 days has expired. B has neither paid the price of goods nor taken the possession of the goods. That means the goods are still physically in the possession of A, the seller. In the meantime, B, the buyer, has become insolvent. In this case, A is entitled to exercise the right of lien on the goods because the buyer has become insolvent and the term of credit has expired without any payment of price by the buyer.
That's all. So if he can exercise right of lien, leave it. Go to the next question.
State the difference between sale and agreement.
Agreement to sell. Okay, this you all can read on your own.
And next, that's it, sir. From Sale of Goods Act, that's it. Next,
Okay.
Contract of partnership.
So what we'll do is we'll wind up. You want to do 1 or 2 questions from Indian Contract Act, or we'll, if we have another chance, we'll meet it all. You all will read it on your own. Is that okay with you all?
Okay, sir.
Yes, sir.
Okay, all of y'all, hope you all have understood. If you all have any doubts or if you all have anything, please contact CAPS. They will give you my phone number and you can always, or you can, Bhavna, you have my email ID, no? So tell this person wants to
Yes,
contact you, send that person's number. I will call that person up. Correct or no?
Yes.
So if you all have any doubts or anything, you all please do that. But I just gave you the gist of how the paper is and I gave you all some questions so that you will get an answer what, because it's very difficult. If I would have done all the Contract Act, Sale of Goods Act and Companies Act at one time, it wouldn't have made sense. But now you all are getting a gist of how they will ask questions in your paper. So remember 60 marks, 12 marks plus 48. Correct or no? 12 marks compulsory, 48 marks. You have to answer any 5 or 4 out of 5 questions, right? And I've already
Sir.
told you how to answer the questions. So best of luck, all of y'all, right? Okay. Thank you so much. And we will catch up next time, right?
Thank you, sir.
Thank you, sir.
sir.
Bye, sir. Thank you, sir.
Thank you, sir. Bye, sir.